Afternoon viewers, welcome to another section of our Facebook Live. This is Law Ascent and I'm Adida Malabi. This afternoon we'll be talking on how to structure partnership business in Nigeria. You will agree with me that for business owners, there are different options of starting out a business. They can either choose to start as a sole proprietor, that is carrying on the business just by themselves without any other person coming to join in the running of the business. There's also another option of registering a partnership business, starting up your business with another person. That is to start a partnership business. We also have the option of incorporating a company. So this afternoon we'll be talking on partnership. And by way of definition, partnership is the coming together of one or two persons to start up a business, and it's always with a common goal, and that goal is to make profit. Another thing to note is that when starting up a partnership business, there are different types of partnership which you will need to understand. And this type of partnership include general partnership or limited partnership. And when we talk about general partnership, it talks about people coming together to start a business. They share the profits, they carry on the management together, they share the loss, they're running around, the getting of clients, day-to-day activities. It is borne by the two parties. But for the limited partnership, it is also referred to as sleeping partnership. This is a situation where you have two or more people coming together to start up a business, but one of the partners is such that is very dormant. The participation is dormant and it's not as active as the other party. And in a place of limited partnership, the principle is always, or the style is always, that the sleeping partner only contributes his finances to the business. It does not participate in the management, does not participate in the decision making, though it might be active in the decision making, but most of his contributions is finance. That is what the person is bringing on board. So when starting up a partnership business, parties need to identify the kind of partnership which they are opting for. So once you get a person, once you form a decision to start up your business as partners, you need to identify the kind of partnership which you decide to opt for, how you want the business to be managed. So where you choose to opt for general partnership, that is to say all partners will be involved in the management of the business. Also, we have situations where there are people who are willing to start up a business, but they do not have the time and resources or even technical know-how on how to go about the business. So in situations like this, at times they get someone to come on board who put in expertise, put in experience and knowledge of the business. So the other person just puts in financial resources to the growth and management of the business. So that is, now we've identified the types of partnership. We said we have general partnership and we have limited partnership. So the next option is, fine, you've gotten a person to start your business. You've identified the kind of partnership you want to go into. The next thing to consider is the registrable options. And what I mean by the registrable options is, what kind of registration do you want to give this business? In law, we have two kinds of registration majorly for business owners. It's either you have, the first is to register a business name, which is a style under which you carry on your business. It is an umbrella under which people carry on your business. A business name can also be referred to as a trade name, but it is not a legal entity. It is not a legal entity compared to an incorporated company. So when you form the decision to start up a business, a partnership business, partners also need to agree and decide on the kind of registration. Under the law, partners can still maintain to register their partnership business as a business name, and they also have the decision to opt for a registrable option of registering a limited liability company. But irrespective of this option and the choice of people to register a kind of business, there is this imposition in law that where two or more people to the maximum number of 20 comes up to register a business, they can choose to register a business name and incorporated company. But where the number exceeds 20, it is mandatory to incorporate that kind of business as a limited liability company. So, by way of recap again, we've said you need to identify the kind of partnership you want to go for, such as general partnership or limited partnership. I've also further mentioned that you can register your business, your partnership business, as a business name, or you incorporate a limited liability company. So what you need to note on the registrable options is your number. You look at your strengths. So if you have a strength of 20, if it's still at 20, you can register a business name. But when the strength of the business or the number of partnership exceeds 20, you are mandated to incorporate a company. Another thing to note on partnership in Nigeria is partnership business or partnership arrangements can be made orally between parties. That is, you can get someone to start up a partnership business, you discuss together, you explain what your visions and objectives, what you want to achieve in the business, how you want it to be managed, and all that. You can do that orally. But note, however, that an oral agreement is not enforceable in law. So for you to have something to back up your business, or for you to have something to back up your relationship, it is always advised that you have a written and documented paper. You have a written agreement and you document your understanding. This is going to avoid the issue of having to go back and forth when issues arise, because fine, you can start up a bank. No one starts a business with an aim to have issues on the long run. But then there are situations where some issues arises as the partnership goes on, which, if not properly provided for in a partnership agreement or a document which parties can refer to, may pose issues that might frustrate the business. So it is on this basis that we always advise that when starting up a partnership, you have your agreement or you have your terms of the relationship documented, because it is going to save you a whole lot of deal, and it will even help the smooth sailing of the business, because you don't have to keep discussing on issues when the business is being faced with challenges. When you have your partnership agreement or your partnership documents, you have it documented, it will help you to have something to fall back on when issues arises in the business. And another thing we'll be talking on this afternoon is the basic terms or the essential terms which you need to have in your partnership agreement. Fine, we've said that you need to have a partnership agreement. It will also be good to educate you and also inform you and bring to your knowledge and attention salient matters which you need to put down in your partnership agreement. It's not just about drafting a partnership agreement, it's not just about documenting your terms, but it is also necessary, it will also be helpful to have very cogent points and understandings documented. And this afternoon we'll be looking at these salient points. And the first one I'll be talking on is the roles and contributions of partners. In every partnership agreement or in every partnership relationship, it is good and it is always better to have the roles of everyone identified. By having the roles of everyone identified in a partnership agreement, it will help to curb the issue of a person sleeping on what he or she is supposed to do, or it will also help to reduce the burden of work in a partner, When you have your roles and contributions of partners documented, it will help to achieve productivity in the office, in the business, and it will also inform each partners on what is expected. And the roles and contributions of partner, it can be, you can streamline it. A partner, the role of a partner can be to finance the project or to finance the business. The role of another partner can also be to get a client base for the business. You can also have the role of a partner to get expertise for the business. So these are things that partners need to understand when drafting a partnership agreement. You need to clearly spell out the roles, what is expected, what are the obligations of each partner. These are things that you need to document in your partnership agreement. Also, talking on contributions, if partners are bringing in fund into the business, it is good to state the percentage or the amount of financial obligation that a partner is expected to bear in a business. This will also help the finances of the business of the partnership business. And also another important feature important feature you need to have in your partnership agreement is the sharing formula. Everyone will agree with me that every partnership business is set up for the aim of making profit. So it is then necessary, or it is then required, it is required that you have your profit sharing formula in a partnership agreement. Because we've seen situations where people come on to start up a partnership business, you have someone bringing in a chunk of the finances, we have someone bringing in just a very minute part of the finance required for starting up the business or for the running of the business. So in situations like this, it is advisable to have the profit sharing formula, because it will not be equitable, it will not be fair to have someone bringing in a huge amount to share profits at the same rate with someone who is contributing very small finances to the business. And one major disadvantage of not having this profit sharing formula agreement in your partnership agreement is the fact that the provision of the law provides that where parties fail to expressly state how profit is to be shared in the business, it is presumed that that profit will be shared equally. So this is to say that where you fail to state what a person is going to get, the profit returns on a business, the provision of the law will be made to apply in such situation, and which will not be fair to a party, because of what I said earlier on parties having different financial obligations and percentage in the business. So it is therefore necessary to have your sharing profits formula in the partnership agreement. Another thing to have in your partnership agreement is liabilities of each partner. No one starts a business with a dream or a vision to run into a loss. But then there are situations where economic challenges might face the business and the business might run at a loss. What is the rule guiding this liability of partners? These are things that should be expressly stated in your partnership agreement. Because going back to the provision of the law on liability of partners, the law also states that liabilities is to be shared jointly. But if you have it stated in your partnership agreement that in the case of liability, this is what this person is going to pay, this is what this person is also going to pay. So it is therefore necessary to talk on liabilities of partners, so everyone will be able to identify the level of liability and how culpable a person is going to be when it comes to liability or in the face of loss or debt owed by the company or the business. Another thing that is to be included in your partnership agreement is also to expressly state that partners will not be liable for debts accrued to the business owing to the negligence of a partner. Because also going by the provisions of the Partnership Act or the partnership laws of different states, it is the provision of the law that a partner can bind the other partner. This is to say that where in the partnership a partner deals with another person, which results in a loss, a partner is indebted to another person on matters that relate to the business. Once it has to do with the business, loss is going to be shared equally. That's the provision of the law. But then where you have in your partnership agreement that your liability is limited to the understanding between yourself and the other partner. So if the other partner goes to commit himself to the tune of an amount that is not budgeted in your partnership agreement or is not within the purview of the partnership agreement, such partner is liable to such debt on his own account. So that excludes you as a partner from liabilities or debts or any loss arising from relationship of a co-partner in a partnership. Advise people to state in a partnership agreement is the issue of dissolution of partnership or cases where a partner has to resign. We've had situations where on the long run, partners in the business, they discover that the business might not be able to go on with the partnership might not be able to go on, or the conduct of a party where a party is in breach of the terms of the partnership agreement. Remember we said earlier that roles and contributions of partners is to be defined in a partnership agreement. So when you have these roles expressly defined and there comes a situation where a person is not abiding by the defined rules or contributions, where a person is not doing what is expected to do in the partnership agreement, what is the way out? These are some of the issues you need to put in your you need to consider in your partnership agreement. So we've had situations where we've had to put in clauses to the effect that where a partner is not complying with his duties or obligations in the partnership agreement, you can state that a notice will be given to such a partner. And when the attention of such partner is brought to his non-compliance to the provisions of the partnership agreement, what is the next thing? So at times you might have to consider dissolution or removal of such a partner. This is one of the things that you need to include in your partnership agreement. And also we've had cases where a partner is still in the business, but due to circumstances beyond the partner's control, the partner had to relocate to another location. What is the way out? These are things you need to include in the partnership agreement. Also, another thing that should be in the partnership agreement is non-compete clause. And this is a clause that provides that partners in a partnership agreement should not also go into businesses that are within the objectives of the partnership business or businesses that are related to the partnership business. This is to avoid conflict of interest, because if you, let's say you start up a partnership business for pure water making, to make pure water, bottled waters and related products, if such a partner or a partner in this kind of business goes on to establish another industry related to this kind of business, this might create issues in the partnership and it might even relate to diversion of claims. So in a partnership agreement, it is expected to have a clause in your partnership agreement that says that partners are not allowed to go into businesses that are related to existing business objectives of the business. Also, on the issue of non-compete, we've also seen situations where a partner is already into a line of business and someone wants to come on board to start up a business, but the person has little or no expertise or expert knowledge on that kind of business. We've seen situations where people get professionals who are already in the line of business to come on board as partners to start up their own business. So in situations like this, the partners can agree that fine, You are not to compete with this business only to the extent of what you already have in your own line of business. And partners can also undertake or agree that the partners of the business will not convert the clients of the partnership to one's personal use. So these are things that should be stated under your non-compete clause. Also, going back to the part on dissolution, it is also good, or it is also advised that when talking on dissolution or when removing a partner, you have a clause in the partnership business that limits or restricts the exiting partner from converting the clients or records of the company or details of the companies already gathered during the existence of the partnership to such partners use upon exit of the partnership business. So these are points or terms or clauses that you need to consider when starting up your partnership business. Then another thing that you should consider in your partnership business is still on decision making, because you agree with me that decision making is one major aspect of your business that should be carefully considered and agreed upon. How do you make decisions in your company or in your partnership business? Who has the final say? These are things that parties should iron out or discuss even before setting up the partnership business. Because we've had situations where a partner would want to toe a line of decision or a line of step, and another partner would also have a reason why he or she disagrees with such decision or approach. How do you go about decision making in your partnership? Who has the final say? Are there decisions the person can take without having to carry the other person along? These are things you should state in your partnership agreement. Then a major one on decision making is decision making with regards to finance of the company. Who are the signatories to the account of the business? These are things that partners should carefully consider before starting a business. Because if you should opt to consider all these things when the business is ongoing, it will be very difficult to make such a decision, because you would have to contend with either sustaining the business or dissolving the business. So the best time to have all these partnership agreements or the terms of partnership agreements, the best time to discuss it is at the point of registration, or at the point of even making an informed decision on whether or not to start up a partnership business. Then the last thing also that we'll be looking at is the dispute resolution mechanism. How do you want dispute to be resolved in your partnership? Is it by going to court or by dissolving to alternative dispute resolution mechanism? You agree with me that going to court might not or is not the best for a business entity. So oftentimes we advise partners to resolve to amicable dispute resolution. So this can be by way of mediation, it can be by way of arbitration, it can even be by way of parties sitting together at a round table to discuss and iron out issues without involving a third party. So these are provisions that you should have in your partnership agreements. Also, on dispute resolution, we've had situations where there are impending matters in the partnership, or impending matters or issues that parties needs to resolve, that needs to be given urgency. So the fact that you've stated that your disputes will be resolved amicably or will be resolved by an arbitrator or a mediator, we've seen cases where partners have to go to court to enforce or to restrain a person from carrying on things that would alter the status quo. So let's say, for example, if there is a case of partners having issues in the business and parties have to go their separate ways. While parties are deciding on how to manage their affairs and the situation at hand, we've seen cases where a partner would want to dispose of the assets of the business. So what would you do in such an instance? This is a place where you have to resort to the court to get an injunction to restrain such person from tampering with the assets of the business, or even it can even be the account, the finance of the business, money is in the bank account, especially where that person is the sole signatory to the account. So you might need to go to court even while exploring mediation or arbitration. So this clause is therefore necessary to be covered in your partnership agreement. Then I would also like to draw this distinction line, because we've seen cases where people just assume they are partners in a partnership business, and whereas the relationship between the parties is that of a contract. So we've seen, for example, let me say you are a web designer and you've gotten the web design agreement and you need a graphic designer to assist with the graphic works. If you contract or you contact a person to assist with the graphic work, such a person might not be a partner in that kind of arrangement. And we've seen situations where people just assume that such a person is a partner, and as such would want to claim rights and privileges on that kind of relationship. So for every relationship you are going into in a business, it is good and advised to identify the kind of relationship. So this will help you to know if you are even, you can be referred to as a partner, or your services to such a business is that of a contract staff or a contract employment or contract engagement. So these are things that you should include in a partnership agreement. Note that the fact that we've identified these points doesn't mean that is all to a partnership agreement. Parties are at liberty to agree on the terms of their partnership business, because it is why it is a relationship between two parties. What we've just done is to identify salient points which you need to consider when starting up your business. And this is the end of today's section. You can join us next week, Thursday, same time, same Facebook Live at Lower Sen. You can drop your comments in the comment box and we hope to hear from you. Thank you.